All right, good afternoon. I'm Susan Poser, Dean of the University of Nebraska College of Law. Welcome. This is the Roscoe Pound Lecture. This endowed lecture was first given by Roscoe Pound himself in 1950, and it allows us to bring distinguished scholars to the College of Law to present a lecture, which is then published in the Nebraska Law Review. Professor Richard Epstein will present this year's Pound Lecture, and he follows a distinguished line of previous Pound Lectures that include James Willard Hurst, Erwin Griswold, Ronald Dworkin, Archibald Cox, Richard Posner, Cass Sunstein, Jeffrey Hazard, and Jeremy Waldron, among others. Roscoe Pound was a Nebraskan, born in Lincoln in 1870. He was the first person to receive a doctoral degree from the University of Nebraska, and it was in botany. He was dean of this law school from 1903 to 1907, before moving on to Northwestern, Chicago, and eventually Harvard Law School as the dean. While dean of the University of Nebraska College of Law, Pound gave one of the most important and remembered speeches ever delivered by an academic, which was entitled The Causes of Popular Dissatisfaction with the Administration of Justice, and it was delivered to the American Bar Association. He went on to become one of the most important legal scholars of the 20th century. Dean Pound continues to be a central part of this law school from his perch at the entrance to the library, where everyday members of our community rub his brass nose for good luck. We are delighted to welcome Professor Richard Epstein today to deliver the Pound Lecture. Richard Epstein is the Lawrence A. Tisch Professor of Law at New York University. He's also a senior fellow at the Hoover Institution and a distinguished professor emeritus and senior lecturer at the University of Chicago. Professor Epstein's resume is too long and detailed to even scratch the surface in this kind of introduction, and he didn't even really want me to do that. He received one bachelor's degree from Columbia and another one from Oxford, and he received his law degree from Yale University. Professor Epstein has edited both the Journal of Legal Studies and the Journal of Law and Economics. He's published many, many books. His most recent book is The Classical Liberal Constitution, The Uncertain Quest for Limited Government, published in 2014. He's been a member of the American Academy of Arts and Sciences since 1985, and he has received numerous accolades, including the Bradley Prize in 2011. Professor Epstein has taught an incredible range of courses from criminal law to environmental law, administrative law, estate planning, and jurisprudence. He's also the author of many case books, including what I consider the best case book in torts, and the one that I have used to teach first-year torts for almost 20 years, as some of you in this room know. I have a brief anecdote about this, if you will indulge me for one moment before the lecture. This torts casebook is extremely intellectual and difficult for first-year students, and that was something I did not sufficiently grasp when I first started teaching from it in 1995. The difficulty is particularly apparent in Chapter 2, which delves into important but pretty esoteric aspects of tort law in medieval England, as well as other complicated issues. As a new professor, I was very puzzled about how to teach Chapter 2, which just followed after intentional torts. So I decided to just call up Professor Epstein and ask him about how to teach this very dense, though fascinating chapter. I reached him on the phone at the University of Chicago Law School, introduced myself, and told him I just started teaching, and I wondered how much of Chapter 2 he thought I should teach in first-year torts. And he responded, "You're teaching Chapter 2? Don't teach Chapter 2. And I was like, but it's Chapter 2. Anyway, he proceeded to talk with me for close to an hour about how to teach from his book and only use Chapter 2 for my own benefit. It was a wonderful experience for a brand new law professor. The title of Professor Epstein's Pound Lecture today is The Upside-Down World of Financial Takings. Please join me in welcoming Professor Richard Epstein. You have to turn on your...
Oh, I have to turn on my microphone? I don't know what I have to do. It's all this high-tech stuff. It's on, dear. Isn't that on? Yes. And we're not only that, we're on the web. So I am going to talk as if I know what I'm about to say, which is always a dubious proposition. But let me tell you about this conversation that I had with your dean from the other side. because I actually remembered the conversation and talking about it. And I remember getting off the phone and saying to myself, "My, this woman really does seem to carry herself very well. My guess is she'll be dean someday." And indeed, that was exactly what I thought, and I'm happy to say that it has come to pass. And it's not as though we are in constant contact with one another, but we've also had sort of frequent interactions over the years. And it's very great to be here, and to be here in the shadow of Roscoe Pound, who is truly one of the great and ubiquitous figures of the 20th century. And as I like to remind Susan, I think he did his best work when he was at the University of Nebraska. That puts me in deep trouble because he was 37 years old when he left this place, and I unfortunately am now over 70, a fact which I will try to conceal from you if at all possible. Now, the topic I'm supposed to talk about today is the sort of the upside-down relationships dealing with financial taking. And let me sort of tell you how it is that I came to this topic by way of an initial disclosure. This is a subject in which I encountered first not as an academic, but as a sort of practicing lawyer. It turns out that if you were to try to figure out two of the hottest issues that exist today in the outside world, they are the question of how it is that large numbers of state, local, municipal governments, county governments, will handle their pension obligations to their public union employees and indeed other employees. And the second of these kinds of issues turns out to be the question of what will be the treatment of the shareholders of the once defunct and now prosperous corporations Fannie, Mae, and Freddie Mac, which are essentially those publicly chartered organizations, government-sponsored enterprises, they are sometimes called, which in fact were thrown into a conservatorship when they were on the brink of bankruptcy and disaster in 2008, but have taken a comeback since then. And I have advised the mayor of San Jose informally, and I represent several hedge funds in advising them on the progress of these things. And I want you to understand that there are both difficulties and advantages of dealing in these kinds of relationships. The difficulty is one always wonders about your own independence when it turns out that you do have some kind of client interest. The advantage, which I think more than outweighs it, is you actually know something about the problems because you can speak to people who are extremely conversant. And the synergy that you hope to achieve is to take your general knowledge about how these subjects work from your academic work and to match it with the particular information about the disputes in question so as to come to a reasonably coherent understanding both of the problem on the one hand and the general theory on the other. And even though both of these things have come very much back into the news in the last week or two, I picked this topic, I think, some months ago in talking to the dean about it, and I think it's extremely, shall we say, propitious to talk about it on this particular occasion. Now, the title that I gave on this particular topic is one which says that I think we have the whole law of financial takings upside down in these two cases. And let me explain why it is that I think that that's the conclusion by first stating what the conclusion is and then trying to indicate how it is that you reason to it. The way in which it appears that the law is working in many of these areas is that the contracts in dealing with financial reorganizations are subject to all sorts of rather radical revisions by the government on a unilateral basis. And this is in the context of investments that are made where essentially predictability and security of investments are in fact very, very important. The labor contracts are in fact much more complicated arrangements in which the dispute in many cases has to do with the way in which these contracts shall be modified and enforced going forward with respect to labor that has yet to be performed by given kinds of workers. The position that one wants to take, I think, is that the strong enforcement is necessary in the investment context and that the flexibility of management is necessary in the labor context. And the way in which this problem seems to be working out, although we're certainly not sure what the outcome is going to be, is there's a lot of legal authority which stands for the proposition that once a public service employee is hired, the pension rights are vested and fixed so that they cannot be reduced, even with respect to work which is to be done in the future. Whereas when you start talking about the commercial investments, where you've put all your money in and the only question is when and how you will get it back, the government is given much more flexibility in the way in which it can reduce the funds in question. And it seems to me that the opposite is in fact the accurate way. You need to have flexibility in labor management type situations. You need to have predictability with respect to financial arrangements. And so the constitutional arguments that get you into the opposite direction seem to me to require some serious reflection and consideration. Now, in order to do so, it becomes necessary to figure out how it is that you structure the basic law of takings. And there are two ways to do this. One is the sort of highly normative framework that I tend to prefer, and the other is the rather messy situation on the ground with respect to the law. If you're dealing with I think the sort of normative framework, there is no ironclad distinction that can be made between those takings which involve government occupation of private property, which may either be kept or transferred to other persons, on the one hand, and government restrictions on the way in which you may or may not use the property in question. In each case, it turns out there is a taking of some property interest. In one case, the interest is larger. It may be the entire fee simple, or it may be a lease or a life estate. And in the other case, it's a covenant or an easement. But in both of these circumstances, the correct measure is to compensate people for the loss that they've sustained, so that the government always faces a price when it decides to exercise its unilateral option as the eminent domain power within the jurisdiction, as the sovereign with respect to particular property. One of the real functions of a system of eminent domain law is not simply to provide compensation in those cases where property has been taken. It is also to set a set of signals of prices out there to the world at large, so that when the price turns out to be too high, the government will decide not to take it, and you will not observe any transaction. If it turns out the government gains are 100 and the private losses are 1,000, the deterrent effect is extremely important, and the gains that you get are very, very large, even though there's no legal dispute and no intervention and no valuation problem to be dealt with. That is not the way in which the current takings law is organized. With respect to what they call occupations or per se takings, there's a case called Loretto versus Teleprompter, decided some 30 years ago, in which the rule is per se compensation to the extent that a property interest has been lost. But if one then wants to push this a little bit further, the single most important regulatory takings case of the last 75 years or so is a case involving the Pennsylvania Railroad Company in Grand Central Station on landmark designation, and the operative rule that came out of the Penn Central State says that there is no fixed rule that tells you when compensation is owing when the government restricts the use as opposed to occupying the property. It all depends on a very complicated balance of interests between the two sides, and it should be widely understood that a simple diminution in value as a function of the regulation imposed does not itself generate a compensation obligation on the government unless and until there is some kind of a complete wipeout or the property itself becomes something less than economically viable. There are terms like economically viable in this formulation which are very elusive to say the least, and the Supreme Court has not bothered to explicate them in the years since 1978 when this particular decision was first handed down. So the question that one has to deal with in the modern law, unfortunately, is not how these cases would be decided if Richard Epstein was czar and everybody in the room bent to his will. However admirable a situation that might be, it turns out, as best I can tell, to be completely unpersuasive to the current United States Supreme Court, where the liberals and the conservatives may differ on points of detail with respect to the rules, but both sides seem to respect the basic distinction and the very different standards of rules. For those of you who are constitutional mavens, it turns out there's a very strict scrutiny rule with respect to the physical occupation cases, and there's a rather forgiving rational basis standard when you start to switch gears and start to go to the regulatory takings. And the difference between the two standards is, to put it mildly, manifest. Now, if you note, what I talked about under these circumstances is the distinction between the physical occupation cases on the one side and the regulation of use cases on the other side. And our topic is, in fact, financial takings. And the question that one has to ask is, where does this fit into the particular picture? And in order to understand what's at stake in this particular case, what you have to understand is what kind of things attract financial takings, the rather unexplored, unsystematic area of takings law. And one of the things is, in fact, the creation of liens, that is, security interests that are imposed upon property, which stand to be collected upon in the event that the underlying debt has not been paid. So if I have a lien on your property for $20 and you do not pay me the $20 from your other funds, I can foreclose on the lien, sell the property, get my expenses, get my interest, get my $20, and then give you what's left over. You now have what is called the equity or the equity of redemption under this particular type of system. And so the question is, how do we start thinking about liens within a property case? The second area has to do with contract rights. It turns out, for example, that I have a contract right to enforce a particular agreement against you, and what the government does is it decides to force me to sell that right to them so that it can enforce the right in its place. And then the question is whether or not they have to pay, and if so, how much is going on. So it looks at least as though at the outset you're dealing with property interests called liens and contract rights. But in fact, if you go through the takings law, I think most courts have come to the right conclusion that there is in fact no categorical distinction between the ways in which these two kinds of interests ought to be treated. Both of them have some degree of purchase on the imagination, and the only question is to figure out what is to be done with them. Well, when I talk to this issue about many people, their first instinct in dealing with the Fannie and Freddie type situation is that when you're looking at these kinds of rights, what you ought to do is to put them into the framework of the regulatory taking so that there's a relatively low standard of review which will be attached to the examination of the government behavior. And my view is, even within the framework of the two systems that we're talking about, that is the difference between physical and regulatory takings, that is in fact a wrong description and a wrong analysis of the way in which the situation ought to work. In order to show how this thing, I think, does take place, what I'd like to do is to go back to a 1960 case called Armstrong against the United States, which involves a humble situation of a ship lien that is imposed upon a Navy boat. For those of you who are deeply into the law of materialmen's liens and mechanics lien, this case is a treasure trove of information, and to others of you, it will simply elicit blank stares. So what I'm trying to do is to get the blankness out of your expression, to explain to you why it is that when you do constitutional law, if you don't get the property stuff right, you'll always get the constitutional stuff wrong. That is, this is a plea for you to remember that first-year classes in property contracts and torts are the basis of everything that follows, and if you ignore those subjects, you do so at your peril. Now, moving on this thing, what happens is the boat goes into Maine waters. It's a Navy craft, and there is a general contractor. And the general contractor is essentially the maestro, the conductor, and his job is to make sure that all the subcontractors do their work in an appointed fashion, and then he pays them. And in this particular case, a given subcontractor did his work on the boat, and the general contract may have been a splendid maestro, but he was a lousy paymaster, and he did not turn over a farthing or any other sum of money to the contractor. The rule, in fact, in this particular case is that subcontractors who aren't paid by the generals can impose their lien on the property on the theory of unjust enrichment. If you do not allow the lien, then in fact the owner of the boat will be enriched by getting the labor for free. And so the lien is duly imposed, and the United States did not do the honorable thing. It did not pay the lien. What it did is it sailed the boats into international waters and thereby dissolved the lien because the jurisdiction of Maine did not extend that far. And so what the owner of the lien did is he went to the United States and he said, you may be able to sail this boat out of Maine waters, but in so doing so, you've defeated the obligation that is there, and so you now become a general debtor, and I'm a general creditor, and you're worth it. So pay me for the thing that you in effect dissolved by staring it out. And our friend Justice Black, who decided the case, he made a very sensible observation. He said, look, this boat is built for the benefit of all the citizens in the United States. It would be rather odd if 10% of the cost of these repairs should go on this lonely subcontractor in Maine. So in fairness and justice, if the public benefits at large from the improvement of the boat, it ought to pay for it. So I'm going to enforce the lien. And he did so in a categorical fashion. Now that seems to me to be exactly the right result, because if you want to put this into the two framework that I've talked about, the ultimate purpose of any lien that you impose upon property is to be reduced to possession in the event that it is not paid. And once it is a possessory interest, it turns out that the way in which you have to think about it is a per se obligation. If we decide that we're going to use the rule with respect to regulatory takings, where mere diminution in value does not in effect generate any government obligation, what you're going to say is every time you put a lien on a boat, then the government can decide to pay 20% of it, 30% of it, and so forth, and the entire system of financial arrangements will start to come running down. For those of you who've taken and studied bankruptcy, it turns out that we use exactly this kind of rule. If somebody wants, in fact, to keep in the business some property which is subject to a secured loan, the basic rule is that you could keep the property and get the gains from it, but you have to give the other fellow consideration equal to the full value of the lien itself that has been surrendered. So essentially all of our practice starts to work along exactly this kind of line. Now this position applies not only to the cases where the government refuses to pay the lien, but it could apply in all sorts of other situations. So suppose I happen to have a lien on the boat, and what the government does is to say, we're going to give somebody else a priority over you by giving them a first lien, and that is done. You will only have a second. If in fact there's a diminution in value by virtue of putting the first lien on, the subordination of one lien to a second lien is a taking equal to the difference in the value that the obligation has when it's a first and a second priority, which could be very large sums of money in those cases where the property itself is highly variable or uncertain or low value. So the whole system essentially says, in a system where you're working with commercial obligations and you make a loan, the only way in which you can survive is to have the confidence that your priority system on repayment will be guaranteed. Otherwise, if you could give people the kind of haircut by interposing liens or sailing boats into public water or entering into various kinds of agreement, then the entire system of commercial credit will come to a halt, and it's simply too high a price to pay. So we put these things on the per se line. Now with that in mind, let's turn a little bit to the Fannie and Freddie type situation so you can see the way in which this is organized. The year is 2008, the month is July, and frankly, my dear, things are getting a little bit rickety in the financial markets in the United States. I take no personal responsibility for the policy of the Feds, but it turns out that what we did is we had a lot of cheap money going around there. People bid up the price of assets to get the advantage of these low loans. It turns out that the underwriting practices that were engaged in by the government when they took these loans over were rather rickety. So when the market starts to turn down, it doesn't turn down slowly and serenely. It starts to go down with a magnificent thud. And the question is, what are we to do? And the United States has a Housing and an Economic Recovery Act, and it creates something known as the Federal Housing Finance Agency, and it's to be put in charge of trying to figure out what we're going to do when, as and if a credit crunch starts to hit. And in September 2008, in the midst of the presidential campaign, that moment seems to come, and what happens is that the Treasury Department and FHFA arrange for a comprehensive bailout of the Fannie and Freddie operations, to the tune of about $188 billion, which even in today's counts as real money. The question is, what do they do? And they enter into a deal. And a deal makes perfectly good sense. And the deal is, in effect, that what we will do is we will advance to these two corporations this sum of money which will allow them to stabilize their balance sheet. And in exchange, we will take back something known as a senior preferred issue. The senior preferred, in effect, is the first priority. It carries essentially payments of 10% if it's paid on time, and 12% if you decide to defer payments in order to husband the cash. Perfectly common commercial kinds of arrangements. There is also a more controversial procedure involving the creation of warrants against the common stock, where the federal government reserves the right to preserve 79.9% of this stuff for some tiny fraction of a penny, 0.0000, that's 4 zeros, 1 cent per share, which clearly is a rather bargain purchase. And they do it on 79.9% because they don't want to have to file a consolidated balance sheet in which these particular obligations now appear against the federal government. So is this a good or a bad deal? Well, you can argue about this, but let's explain the logic with respect to the senior preferred in a way, I think, which makes the government's case. The government is saying, look, we have certainly taken your property by putting a first lien, because remember, you already told us in the general analysis that if you subordinate somebody else and you take the first position, what happens is there's a taking of property. But by the way, guys, we just didn't impose this lien upon you for no good reason at all. What we did is we advanced you $188 million. And so when the dust settles after this transaction is done, here's what happens. We have a first lien with a nice interest rate. And what you do, in effect, is you have a solvent corporation, because the money that you receive in is worth more to you than the subordination of the position that you take, so that in the end this becomes a win-win transaction, which is exactly the way in which government deals are supposed to work. Things are much more complicated with the question of why it is that they took these options for nominal prices on the common stock. I'm not a great fan of that practice, but again, it often takes place in commercial arrangements, so at least for the moment I will just let that thing ride. So far, in effect, what we do is we have a government bailout that seems to make sense if, in fact, the values are commensurate to one another. And one of the things that you know when you do takings law is that you don't want to be in the position of a court when these markets are moving very rapidly to try to make sense of the question as to whether or not the terms are precisely equal. The valuation is simply too difficult, and it's not as though you've got a perfect market sense going out here, but you've got some sense that these numbers look about right. The arrangement, however, is more complicated than all this, because the deal that is made between the Treasury, and it is not made with the shareholders of Fannie and Freddie through their board of directors. At the same time the deal is made, FHFA basically dismisses from operating control all of the directors, so it's two government agencies entering into a deal one to another, which always raises the question of self-dealing, which in this case is answered reasonably effectively, at least insofar as we're talked about the senior preferred, on the grounds that the quid pro quos seem to be about right. Now, the market starts to improve, and then we have a lot of complicated stuff going on, but the key event is in August of 2012, where they enter into what is called the Third Amendment to the Basic Agreement. And remember, the shareholders are not represented, and the board of directors is a government agent. And what they do is they essentially make the following proposition. We're going to release you from the obligation to pay that 10%. That sounds good. But what we're going to do is to take in exchange a dividend sweep, which gives us the right to all of your dividends, whatever their amount. And it turns out 10% is chump change compared to the $150 billion or so that gets paid in, when the amount of money and interest is owed is a tiny fraction of that amount. So what the government has essentially said by this particular self-dealing transaction is that you will never get out of insolvency because we will never allow you to pay down the debt, because all the money that we receive by way of transfer, we will now denominate as if it were a dividend. So we do very well, you do very horribly under this kinds of thing, and frankly, my dear, if you don't like it, go stuff it. Now, that's not exactly what happened, because this particular transaction brought forth a veritable visit of lawsuits by a group of individuals who said, look, you can't possibly mean what you've done in this case. You are a conservator. You're designed to preserve the assets of this particular state. And the statute says that when you've paid off the debt, what simply then is that you return through orderly procedures the company in question to all of the original shareholders, and you reinflate the company. So basically the dispute is the government is saying they're only dividends, the debt is not repaid, so the corporations are still insolvent, so it can wipe them out. And what the shareholders are saying is, you can't do this. It comes to litigation, and the government's position, to my mind, is, to put it mildly, astonishing. And it makes a couple of claims, and let me just mention them. One of them, it says you can't protest because the statute in question gives us all the rights of shareholders when we start to represent this country. As if somehow or other, if you have all the rights of shareholders, you can be removed from your fiduciary duties. And since we have all the shareholder rights, you don't have standing to sue because we own everything. To which the answer is, if somebody takes your house and then decides, in effect, that the government has title to the house, it's saying, you can't sue for the house because we have title to it. So the argument is, if in fact this statute is to be enforced as met, then it's an illegal statute. It's unconstitutional because the taking of the shares without compensation is just a prelude to taking of the money of the shareholders without any just compensation. And so what you have to do is to strike it down as an unconstitutional situation if you construe it as it's drafted. But the sensible way to read it is to say, look, the statute really does apply and gives the government all the rights of the shareholders in dealing with third parties, but it doesn't wipe out their rights. And then the second major point that the government makes in this kinds of case is to say, you know, look at this thing, you're really not worse off because beforehand there was a lot of instability and uncertainty with respect to the market, and now we've eliminated the uncertainty. Well, they did eliminate uncertainty. What they did is they eliminated the uncertain prospects of coming back with money, and they gave you a sum equal to precisely zero, so you're certain to lose under this particular kind of transaction. And even if you met the fair exchange requirements that were associated with the 2008 type of situation, you certainly don't meet them here. This case is now before the courts, and there will soon be discovery on it, because one of the things that the government did on its motion to dismiss you, civil procedure students should learn from this blunder, is on a motion to dismiss you do not deny the facts that are alleged by the plaintiffs. The plaintiffs allege, truthfully as it turns out, that these companies were now being back again. The government says they were still in a parlous state. So now you can take full discovery on this issue of all the government records because they put a fact into issue when you're supposed to, on a motion of pleading, say you get rid of the case even if the plaintiff's facts are true as alleged. Very important lesson, and there'll be some very powerful people who will have their depositions taken. There'll be a lot of documents that will be disclosed. My own prediction is I think the government's case is really vanishingly weak on this particular situation because of the audacity of the overall transaction and the total deviation that it has from standard principles. To put it in another fashion, there are all sorts of rules that are associated with receiverships, with conservatorships, with bankruptcy proceedings of one kind or another, and you can't run the world in which the government can dilate all of them and get away with what it is. So I don't think that they will win this case, notwithstanding the normal deference that is given to the government in the regulation of complicated affairs. This was a series of contracts. They were preferred stock shareholder agreements, and what the government did was simply go beyond the authority that the contracts gave them, so that the normal deference that is given with respect to legislation will not apply to these transactions. Now, the situation that we have on the other side with respect to the labor contract is exactly the opposite situation. What happens is if you're the mayor of San Jose, or indeed of any other city, you are basically engaged in a juggling act. You have a finite set of resources, and it turns out that no matter how large that finite set is, the demands that are made on it is always larger than the resources that you have to satisfy them, so that you're left in the regrettable position of trying to figure out what you're going to do in order to make these kinds of cuts. And the correct sort of way to think about this stuff is in connection with the business judgment rules of corporations. The ideal that you have when you look at your dollars in your city budget, if you're a conscientious mayor, as Chuck Reed surely is, he's the mayor of San Jose, is to satisfy what is technically called the equal marginal condition, which is you take a dollar and you say, I'm going to give it to that particular area where it has the largest pop. And if you've really done this thing correctly, it means that when you get this new dollar in, it doesn't matter where you allocate it because everything turns out to be in equilibrium. In practice, it never stays there very long because demand and supply conditions, budget conditions, and everything else switches, so that you as an administrator are always out of equilibrium and you're always trying to get yourself back into equilibrium. And that's what our beloved dean here does every single day when she's working in this law school. And it's what every administrator does. The only thing that you need to have in order to make this scenario accurate is scarcity on the one hand and multiple objectives on the other. The nature and the source of the scarcity doesn't matter, and the kinds of objectives you have may differ, but it doesn't matter for the basic analysis. Now, in giving these kinds of situations, what you then have to do is to ask, what's the appropriate legal framework that you use to judge the decisions of a mayor a chancellor, a president, or anybody else who has these multiple inconsistent obligations. And at this particular point, you go a full 180 degrees from the fair value rules that we talked about with respect to the loans and the advances that were made to Fannie and Freddie. And what you put into its place is something known as the business judgment rule. And what that says is, trying to figure out equal marginal conditions is a very difficult kind of thing. And we are almost sure that in each and every case you are going to make a mistake. But if you're acting in good faith, the mistakes are sometimes too high, sometimes too low. So we're faced with two choices. One is every time somebody is disgruntled, they can sue and hope to recover the correct amount that the equal marginal conditions would suggest, at which point everybody's going to be suing everybody at every time. Or you could say, frankly, my dear, we really don't know what's going on here. That's why we hire presidents, mayors, and deans. They have to work with their budget committees, and we give them discretion so long as they're acting in good faith. So there is a very deep and powerful set of explanations of why it is that the strict obligations that you want with respect to the repayment of money which has already been lent does not carry over to those cases where you're trying to figure out how future income streams ought to be allocated to future projects. The two problems are completely different, and you have to get different answers. Now, when it actually comes to the way in which this works in California and many other states, it's exactly the opposite. It turns out that if you look at contracts clause jurisdiction and jurisprudence generally, there is all sorts of forgiveness and play in the joints, even with respect to commercial obligation. And this is very uneasy, because sometimes you could retroactively invalidate certain transactions under the Commerce Clause. But in this case, the California courts and many other courts have come to the conclusion that the moment the worker is hired, the pension benefits as set out in the standard contract, be it union or non-union, are fixed. Even though you may be able to fire somebody, demote them, change their jobs and their salaries, the pension obligations are there forever. Now, how did they get to that particular conclusion, and what ought we to say about it? Well, the first of these cases, called Kern, is a situation back in the 1940s where there were some firemen, I believe, and they had worked for a very long period of time, and they had themselves some pension rights which would vest upon their retirement. And a few days before the retirement was to take place, the local government decided no pensions, thank you and goodbye. And there is no question that there's some degree of discretion, but when you cut somebody up after all the work has been done and give them nothing in exchange, and you claim a business judgment rule, you can't make out the equal marginal argument that we're talking about before. It looks like a double cross of one kind or another. And so what the court said is, you cannot do this. If you want the private analogy, suppose you work for a corporation, and the corporation reserves the right to alter or amend your particular pension, and the day before you retire, they pick you out and they say, you and you alone are going to get nothing. Most people would find some equitable doctrine which would allow you to overcome that kind of behavior. And indeed, the reason why you see it so infrequently is that in private markets, the reputational hit to an employer that did it with one set of employees would be so great that they would not be around alive or in business if, in fact, they tried to do it a second time. But that's the way in which the doctrine starts to create a certain degree of rigidity. But when you then start moving on into other cases, the rule starts to take a very different characteristic and hue. And now what happens is by the time you get to a case called Allen in 1955 or so, name doesn't really matter, what they say is you do have the power to alter and amend, but any alteration and amendment that you start to make is one that has to follow the following conditions. It must, in terms of the present value to the individual workers, leave them as well off after the alteration or amendment as they were before. So in other words, you can fiddle around the timing with which people take money, but you can't reduce the total size of the obligation. If you're the city of San Jose, and it seems under current estimates, themselves highly questionable and difficult to ascertain, that you're talking about a $3.7 billion deficit with respect to unfunded pension liabilities and future work, the only thing you're allowed to do is to change the timing, but there's nothing that you can do which will reduce the amount of the total losses. So the people of San Jose did not like this situation. And what they did is they passed something known as Measure B. And what that provided, in effect, was for an orderly reduction with respect to future payments on pensions for works that have not yet been done. And the theory of this particular situation is if you introduce that kind of flexibility into the hands of the mayor, you can undo some of the other kinds of real dislocations in the city when the pension funds have absolute priority over everything else. You could reopen the library 6 days a week instead of 3. You can start to keep the parks open. You can continue to hire more teachers. You don't have to lay off a large portion of your local police force and so forth. So the way to understand this particular case is that it's a priority context in which all of these other uses are meritorious and every one of them is subordinated to the pension unless the alter and amend power allows you to achieve the result of the equal marginal reductions. When the case goes into the California system, the judge in that particular case, she decides, you know what? I've seen these early precedents, and you cannot, in effect, reduce the amount of the pensions one bit. And so therefore, the various uniformed services, the policemen and the firemen and so forth, they get dollar for dollar. She says all of the stuff associated with the local kinds of disruptions of fundamental services are not legal issues. It turns out, according to her, they are only political issues, which she does not have to take any kind of cognizance of. And it seems to me that that willful kind of blindness goes against everything that is understood with respect to the entire realist tradition, of which our friend Roscoe Pound was a member, in which when you start to look at the way in various kinds of obligations are going to be organized, you at least cast more than an idle eye to the consequences that follow from alternative economic and social arrangements. And in this particular case, if the equal marginal concern is in fact a valid one, as I think it is, then this particular reading of the statute turns out to be rather grotesque. So what is it that you ought to do? Well, the one thing you should know is that all of these local charters are not strict obligation charters. They do give powers of alter and amendment explicitly in the agreement. And indeed, if you take all the arguments about separation of powers seriously, it would be highly inappropriate for any government to essentially contract away its ability to modify its contracts in the future to some private party, because that would violate its own sovereign obligations to make sure that it keeps its budgets and its essential functions in place. To be sure, you have to enter into certain kinds of long-term contracts like loans, in which you have to make secured arrangements. But with respect to future work that is undone, go back to your first-year contracts classes and remember that to the extent that promises are still executory, there's a great deal more fluidity in the situation than where one side has performed in full and the other side only has to perform. Where the sequence of performance is I go first and you go second, we have to have strong rights to make that number two works. But if in fact we are constantly engaged in simultaneous and reciprocal performances, there's a great deal more flexibility. And those workers who don't like the current deal can decide to go elsewhere so that they have some degree of protection. And there's no way that a lender, once the money has been lent, can decide to go elsewhere to recollect that money from some third party to whom it was not lent in the first place. So if you look at all of this, it seems to me that the appropriate approach is to make sure that the current decision is kept up, but that the other decisions which run in the opposite direction and say no reduction is allowed are utterly inconsistent with the contract as it is in fact drafted and utterly inconsistent with the way in which you work these situations. What you have to, therefore, is to figure out what's going to be the arrangement, and I think I'll sort of end on this point because we're kind of coming to the end. And essentially, it's going back, not the constitutional law, which tells you very little, but you have to go back to your contracts law and realize that one of the central units of contract study is always the question of how it is when there is a bilateral monopoly, modification and renegotiation of these terms take place. And by the bilateral monopoly condition, we mean that if you have an ongoing contract, the only place from which the county or the city can get its relief is from the workers, and the workers can't go anywhere else if they don't like the deal that they're given by the city. So you get this kind of contentious arrangement, and the terms that are used to try to deal with that are the terms of talking about renegotiations in good faith. And essentially, you then have to figure out what that's going to mean. And the way in which I think it applies in this particular case, though not in others, is that you are trying, when you do this renegotiation, not to engage in a wipeout, because that would be abuse of authority, But what you're trying to do is to satisfy these equal marginal conditions. And so what you look around and you say whether or not the cut with respect to the pensions that are going to be paid on future labor are roughly proportionate to the gains that you're going to get by able to increase the activities in other areas which have been surely shortfall. So if in fact by the end of the process it looks as though you're back in some kind of equal marginal equilibrium, you've done it right. And if it turns out that you're not even trying to get it there, you've done it wrong. As in the valuation cases, with respect to how much the bailout money was worth, there has to be some deference given to local officials on these questions of valuation. Now, what happens if it turns out this doesn't take place? Well, you have to understand there's also Detroit on the horizon. And with Detroit, the situation got so bad that there was no way that you could fix the stew by simply looking at future obligations of current and future workers. What you had to do is to throw the Bing into bankruptcy, and the bankruptcy lawyers here will tell you, sadly but truth, that the guys who would earn their workers are unsecured creditors of the city, and so forth will take a subordinate position, and the haircut can exist not only with respect to future labor, but also with respect to the accrued pensions. My own view about all of this is that when you're facing that kind of an abyss, the correct strategy on both sides is to come to the table. Now, one of the things that we know is it doesn't happen. If you look at the private union type situations with respect to various jobs in the automobile industry, in the steel industry, in the tire industry, and so forth, what you do is you see massive reductions in force when the industries themselves are unable to meet the obligations in question. That what typically happens when you have bilateral negotiations with consent to both sides needed is the adjustments are made too little and too late. What you really need to do is to switch the paradigm to the one that I've said, where in fact you have unilateral powers to renegotiate or to redefine these terms subject to a good faith obligation. But this then leaves you with, I think, a sobering and important lesson. When you're dealing with institutional complexities, you are always asking the question, not what is right and what is wrong. You're trying to ask the question as between two imperfect types of arrangements. Which of these is going to give you the greatest danger? And it turns out, I think, that the unilateral good faith alternative as opposed to the bilateral mutual consent arrangement is in these cases, the former, much the safer alternative. We have seen too much taking place by way of wreckage. If you looked at Measure B, it's not trying to wipe people out in San Jose. So in my view, going forward, the courts ought to sustain it and reverse Judge Lucas, the woman who wrote the decision down below. Whereas at the same time, when you're dealing with strictly sequential contractual obligations like in Fannie Mae, the government cannot unilaterally decide not to pay its debts or to simply take somebody else's property by fiat and self-dealing. So the thing is indeed truly upside down. And my hope is that when these things do go through litigation, what is now upside down will be turned right side up. Thank you. Well, this is not scotch, so I can still answer questions. Does anybody have a question? Come on. Come on. Yes! In the back.
In the environment where you have condemnation that involve water rights in a bubbled environment with increasing value for the land and the right of the water, would you argue then for an equal marginal equilibrium subject to good faith negotiation between government and the landowner?
Nope.
What would you argue for?
Well, you see, what happens is, in those particular cases, what you do is you have a private right, and the land and water for these purposes, I don't think, ought to be treated differently, although obviously when you get to a state like Nebraska, which is a big water law state, anybody who teaches water laws, I actually did this past fall to immense profit, everyone should take the course. Should be a required first-year course. No, a bit much. It's a much more fluid system, and I mean that as a pun, which the water flows so that the property rights themselves, by necessity, are going to turn out to be less definite. But the correct rule in those situations is the one that applies with respect to the sequential performance, where the contract that we were talking about, I perform first and you perform second, because the government has put nothing on the table. And so the correct way to get this thing is figure out what the water rights are worth in their private use and what the land is used, And what you then do is you get the government condemn them at the combined value. Now, this is one of the truly outrageous areas of American modern constitutional law, because what happens is the way the condemnation system works is there is a complete disjunction between the private rights on the one hand and the public rights on the other. So there is a particularly bad decision by Justice Douglas in 1955 or so, in a case involving the Twin City, I think it was called, power plant. And what happens is the plant is on fast land, and its value comes from its access to the water rights. It is understood by everybody that if, in fact, a private party disrupted their ability to use those water rights, it would be subject to an action in tort. The correct rule, therefore, is whatever is tortious in the private area is compensable when taken in the public area. But there is, in this particular area, and this may be what you're referring to, something known as the paramount navigation easement, which says when the federal government runs one of these rivers, it can simply wipe out any and all private interests so that it's paramount and dogmatic, whereas most water rights are correlatives. And this means, for example, that any access that a riparian has with respect to the water is not going to be included in the compensable base. And that's a mistake because the purpose of the taking system is generally to give you compensation, as I mentioned at the beginning, to have some check such that when the government exerts its power to condemn, we have reason to believe that the land in public hands is worth more than in private hands. And if you just ignore all of the rights to the water that are recognized under the state law, under the name that the navigation easement takes priority, you completely disrupt that kind of an arrangement. So in all of these situations, what you're trying to do is to figure out what legal rules should be used in order to increase overall net efficiency. It turns out in cooperative ongoing arrangements, the good faith standard is dominant, whereas in those cases where there's unilateral exaction, a strict scrutiny system is within. So to give you but another example, if you're trying to think about government enforcements of its law in the areas of race, my view is if you're trying to figure out how you run or don't run an affirmative action program in a school district, you have to give the local guys a lot of discretion, given the huge difficulties in operating these cases. But just because you're willing to give them discretion in the way in which they run their own business doesn't mean when it comes to the enforcement of the criminal law, you can say, you know, we're going to subject black people to twice the criminal penalties for the identical white offense as a white person or vice versa. Essentially, the government has much less discretion, in my judgment, when it engages in coercion and regulation, and much more discretion when it engages in management. And this is exactly the way it is with respect to private businesses. You run a private organization, you may be able as a charity to get immunity for the way in which you provide your medical services to the indigent and even the paying customers that come to you. But if you, in order to run this plant, actually pollute a nearby river, the immunity disappears and you are held liable as any other institution. So once again, if you understand how the private and the public interactions take place, you'll be able to see the way it works. In my book on the classical liberal constitution, I go through in nauseating detail all of these kinds of arrangements to see that this balance can in fact be preserved. Okay? Any other questions? Come, buddy, come on. I don't bite. Yes, I do bite. Go ahead. Richard.
Could you discuss the Durbin Amendment, the Dodd-Frank Act, and whether that's a taking where banks are limited on the credit card?
I want to hit you, but I will discuss it in a sec. That was also a case I worked on. I don't know if you're aware of that. Right? And in fact, it represents the kind of mindless behavior that only the United States Congress is able to deal with. Let me tell you first what the amendment is, how the thing operates, and why it is that you manage to lose all your freebies with respect to your debit card. And to begin this story, you always have to go back in time, and let's go to 1995, when banks start to induce debit cards. And what a debit card essentially allows you to do is to pay with a piece of plastic and not carry cash around. But although it's not 100% true, essentially what it is a kind of a monitoring device. You can't use debit cards above and beyond the amount of money that you have in your account. That's actually wrong, but for these purposes, close enough. You can't run up huge bills. It turns out debit cards are immensely popular, and the system spreads like wildfire. So that by about 2008 or 2009, what happens is whether you look at total number of dollars through the cards, a total number of transactions, the debit card has now become the ubiquitous card, relative to the credit card. In part, that's because there are many people who don't qualify for credit cards who can get debit cards. So essentially, you don't have to go to these cash operators and these payday loan people in order to do it. You could use this system. Well, one of the things you have to understand about the American Congress is the moment you find a viable, widely accepted public institution that is making profits for everybody, you better regulate it because you can't allow that situation to go on. And what then happens is that Senator Durbin, under the influence, and this is all in the public record, of the head of Walgreens, says that, you know, Walgreens says, our fourth largest expenses after rent, salary, and health care is debit interchange fees. You got to do something. The correct answer is, oh, it's your fourth largest expense. You're not stupid. You're making a lot of money by using debit cards because they give you a lot of advantages which offset the interchange fees in question. And now, what are these interchange fees? Well, debit cards don't come from heaven. They come from banks. And it's a very complicated system of distribution. And in the middle is your credit card company, typically Visa or Medicare, or Master. Medicare is not in the credit card business, so they'll wait a little bit and pretty note to make up their other losses. They might try. Visa and MasterCard, right? And what they do is they have tentacles in both directions. On the one side, what they do is they collect through what are called merchant banks, the interchange fee from all of the merchants and retailers, which in the olden days was about 1.2 or 3%. And then it's funneled through those characters, and then it goes over to the customer bank, and it goes back to the customer. So essentially what happens is, in this kind of complicated market, the retailers and the merchants pay all the expenses of the fees. They go to the banks on the other side, which then use the money in order to bring more people into the system. The more people there are in the system, it turns out that the greater number of accounts that you could spread the fixed cost over, and the system kind of grows like Topsy, because the job of the company in the middle is to make sure that the two sides are always in balance, and they do it by good faith modifications as explicitly set up in their contracts. That's the way in which they work. And we know that this works because there's virtually no litigation that takes place. There's a little bit of competition in there. And Senator Durbin comes through and he says, no, we don't like this system. It turns out we think everybody ought to pay himself. We're going to get rid of the interchange fees, except to the extent that they could use to authorize, clear, and settle transactions, the so-called ACS charges. So he puts very severe caps on this stuff, and he then charges the Federal Reserve with the obligation of figuring out exactly the way in which these things should be calculated. And this is a massive endeavor, and there's a delay in enforcement and so forth. And what happens is the banks go essentially to the Federal Reserve after they come out with their initial very negative holdings. Say, you know, you could bankrupt this. This is ridiculous. Give us more money. And they did. And so what happens is there are two challenges. The first one's in court that I was involved with, in which the argument was that somehow this is an unconstitutional taking because it turns out whatever the banks lose under the Durbin Amendment, they can't possibly make up by the cross fees. And the court, in a terrible set of opinions, announced that we just have to wait and see what's going to happen, even though there's every reason to believe that the system is inefficient, and it turns out that the customer banks are going to be really hurt and the customers are going to be hurt. But they say, wait another day, and of course that never day ever comes. They said, you may make this money back in these cross payments by charging your own customer. Wells Fargo and Bank of America tried that. They got $0.0 because everybody says, how dare you charge your customers for bringing them into the system? You should be paying, which is, of course, what the old system did. But now, in effect, Senator Durbin, who said originally, charge your own customers, said, how dare you charge your own customers? And he wrote angry letters to the presidents of Wells Fargo. These are online, by the way. And Bank of America saying, you could just cut your salary in half and give out lots of free credit cards. This is a man who truly understands the economics of a large organization. So then what happens is the retail banks come back, not the retailers come back, and they go into federal court in Washington before a judge named Richard Leone, and they say, you know, 21 cents, where do you get 21 cents? The statute says you're only entitled to recover your incremental cost for the authorization of a transaction, the clearance of a transaction, and the settlement of a transaction. You can't recover the cost for building the whole system. And the statute is perfectly clear. And the bankers argue heroically and, in my mind, stupidly beyond all belief, that they got all sorts of discretion. And what happens, therefore, is he clobbers them, and the case is now on appeal. He said, come on, basically. I could read as well as you can. And even under Chevron, there's just no deference here. And in fact, in my judgment, he is right about that. So this is the classic way not to litigate. When you go into the Constitutional Court, you don't want to take the hard line that this is the taking. And since you don't take the hard line that it's a taking under all circumstances, you cannot get an injunction against the activity, because why? They're treating it like a Penn Central case. And the moment you introduce Penn Central and constitutional challenges in the same sentence, goodbye. It's over. Then, when they go and they try to prove, I've lost all my bottles. When they try to prove this in the other court, the judge says, come on. So what they're going to do is, it looks as though they have no constitutional challenge, and then you're going to have to get a legislative fix. But there is Senator Durbin, as ignorant as ever, sitting there in the Senate, who will make it extremely difficult to do these things. So what happens is banks go to other systems in order to get their money, which is why it is that you find that all the freebies are gone, because there's no way in which they will do that to lure customers if in fact they can't get used. And the debit card innovation will start to slow down, because the people who don't understand the operation of these two-party markets have the sovereign authority to regulate and therefore to wreck them. And this is essentially a very serious problem. I've worked too many cases associated with the government, and in virtually every case, it's sort of systematic, willful ignorance has resulted in enormous inconvenience, and you, virtually all of you, are victims of that kind of folly in this particular case. If there's a little bit of anger in my voice, it is richly deserved. All right, I think there's time for one more question or no more questions. 1307, one more question. No more questions. Is there a hand going? Ah, yes, last question. I'll give a short answer, Susan, which is possible, actually. Of which one? Oh my God, I wrote about that too. That was an outrageous decision, and let me give you the very short version. General Motors and Chrysler essentially have a bunch of unions to whom they owe pension obligations, and these were unsecured creditors. There were actually another bunch of unions which had made loans to them, which were secured creditors. And what happened in that particular case is the government found a way to prefer its preferred non-secured creditors to the secured creditors by arranging what is only be described as a totally improper and fraudulent sale. What they did is, instead of selling the assets off and then using them to pay the debts, they said they would only sell the assets off to somebody who wanted to assume the liabilities. Now, unfortunately, in this particular case, the liabilities are many times the amount of the assets, so the correct money to pay is negative. I will take these things off of you if you will give me X billion dollars. But the government goes in there and they make a positive bid. Well, they can make any positive bid that they want because nobody's going to compete with them. And the positive bid that they make essentially allows them to get out of this situation and then funnel the TARP monies into the union-type pen, because what they did in effect is they reduced the amount of money that went into the bankruptcy by not buying the assets free and clear of the liabilities. And this is exactly the same kind of thing that you see with Fannie and Freddie. What's happened is, since many people actually think that Penn Central applies to financial takings, the degree of discretion is very, very large. And if it's large, the results will be systematically ruinous. So we run a real problem in this country, because at the same time the government is trying to wipe out the past investors of Fannie and Freddie, it's trying to raise new private capital. How are you going to raise private capital in a world in which there can be another version of the Third Amendment? And the thing to understand, and I'll stop on this note, is the scheme that they used in the bankruptcy associated with Chrysler and GM and the scheme that they used in the Third Amendment are very different. But it doesn't matter. So long as you can get away with one scheme or another, there'll be a third scheme which will have exactly the same effect of taking superior financial interests and reducing them to an inferior place that I said is a per se taking. Because remember when I talked about the material men's lien, I said improper subordination of a loan without compensation is in fact the taking. And that's what's happened there. And I am done with my answer. Thank you.